Let us look at what we call offer distinguished from invitation to treat. I've defined an offer, but invitation to treat is not an offer. It is a preliminary move for negotiation. It is a preliminary move for negotiation. That is what we call invitation to treat. An offer may be accepted by the offeree, but invitation to treat cannot be accepted because it is not an offer. And so that is why an offer can be accepted, an invitation to treat is only an invitation to offers and cannot be accepted. So all it does is to solicit for an offer. Okay? To solicit for an offer. So that's what it can only do. It is just a preliminary move in negotiation, which may at the same time lead to a contract. So it is an offer to receive. We call it an offer to receive offer. So that is what we call, that is invitation to treat. An example of invitation to treat, we have display of goods at the shop. Display of goods. Invitation to tender or bid. Request for information. Then auction C. Then let me invitation for application. So all these are invitation to treat, is not an offer. Because take for example, where you display goods in your shop, is not an offer, because the person who wants to buy the shoe will still have to come in and then pick the shoe he wants. So is that person who picked the shoe that is now offering, okay, is now offering to buy that very shoe. And there will be a negotiation. So if the seller of the shoe now agree, okay, so the acceptance is now coming from the seller of the shoe. So the display of that goods is not an offer because it cannot be accepted. So that is the display of goods. It's just like a case of Fisher versus Bell. So the case of Fisher versus Bell, where a shop owner display a flick knife in his shop window. So now the issue is whether it could be held to have offered the same for sale and then liable for contravening a statute prohibiting the sale of knife. So and the court held that the display was nothing but an invitation to treat. So it is an invitation to treat for displaying, because when you display something, it does not mean that it is an offer. It is somebody who now want to buy the knife that will now bring an offer, okay, to buy the knife. Then you that you are now selling the knife will now say, okay, this is the price you want to pay, or you accept the price being proposed by the person who wants to buy the knife, and then contract will be established. Also, invitation to tender or bid. If somebody want to build or want to do a thing and invite people to bring bid or to bring tender, so or maybe to bring quotation for building a particular house. So the quotation will be submitted by so many contractors. So it is then the person that is announcing that people should bring such quotation that will now pick the one he wants. So saying that people should bring quotation, for example, is not an offer, it is an invitation to treat. It is other member of the public who want to build for him that will bring quotation. So he will now accept. so before a contract will be established. So his announcement is not an offer but invitation to trade. At the same time, request for information, auction sales, and also invitation for application, where I'm looking for a teacher, and then announce to the member of the public that I'm looking for a teacher. The teacher will now, people will now bring application. My announcement is not an offer, it is an invitation to trade. So people bringing application, okay, application to become teacher in my school are the ones bringing an offer. And I will now pick the person I want from among them. So immediately I pick someone and announce to the person, the contract becomes established. But my first move to announce that I'm looking for a teacher is not an offer but invitation to trade. So it is that person that want to teach that you now bring an offer through his application. I will now be the one to accept. Okay, though I've mentioned some of the examples, just as what I've said, the example of invitation to trade is the one I've already said. So, and that's why I mentioned display of goods, okay, and also of goods. I've also mentioned auction sales, invitation to tender, then a request for information. Let us look at termination of an offer. That is, how an offer may be terminated. So we have number one, how to terminate an offer. So an offer may be terminated by revocation. Revocation is the withdrawal of an offer. An offeror may decide to sell his biro, okay, to the offeree, Mr. B. So he may also decide again after some days to withdraw the offer and tell Mr. B that he's no longer selling the biro again. So that is what we call revocation. Revocation is the withdrawal, okay. So, and then the withdrawal must be communicated. That means that Mr. A must inform Mr. B that he's no longer selling the biro. So that is what we call revocation. So that means that revocation of an offer must be communicated to the offeree. And also I need to let you know that an offeror may revoke his offer at any time. So even where Mr. A promised to keep the offer open for 2 weeks or 1 week, he may decide to withdraw the offer, okay, before the expiration of that 1 week, except where Mr. B has given something for that purpose. If Mr. A promised to sell his biro to Mr. B and then he promised to leave it open for 1 week, and then Mr. B, in order for Mr. A to leave it open for 1 week, Mr. B now give Mr. A some amount of money, okay. Instead of paying the whole amount of money of 100 naira, if he gives Mr. A some amount of money out of that 100 naira, take for example 15 naira or 20 naira, so that means that Mr. A cannot withdraw the offer, okay, until the expiration of that 1 week. But without any consideration from Mr. B, Mr. A can withdraw his offer at any time. So that is revocation. Then the other one is what we call rejection. So rejection is from the offeree. So where the Mr. A tells Mr. B that he wants to sell his biro and Mr. B says he is not interested. So that is what we call rejection. So Mr. B can reject direct. So and inform Mr. A that he is not interested to buy the biro. That is rejection. And also we have under rejection, that means that we have direct rejection like that, okay, from Mr. B, and we have what we call counter offer. Let's have it as express rejection. So we have what we call counter offer. And counter offer has to do with a situation where Mr. A wants to sell his biro to Mr. B at 100 naira, but Mr. B now say he can only pay 80 naira. So that announcement to pay 80 naira is what we call counter offer. So it's a counter offer, and that terminates the original offer of Mr. A to sell the biro at 100 naira. Even where Mr. B now think that, well, let him also go back to buy it at 100 naira, okay? Then it is now left for Mr. A to still sell it. He may also decide not to sell the biro, because the new information from Mr. B is what we call new offer, which is now left for Mr. A to accept. What I'm trying to say is that where Mr. A promised to sell his biro at 100 naira to Mr. B, it is the new offer. And if Mr. B should now say that he can only pay 80 naira, that is counter offer, which will automatically kill the first offer of Mr. A. Then if Mr. B now think again and then decide to return and buy the biro from Mr. B, if he now make another proposal to buy it at 100 naira, okay, that proposal is called new offer, which is now left for Mr. A to accept. It is not compulsory that Mr. A must accept such. So because the first offer of Mr. A is no longer alive, the next step of Mr. B that is now taken is what we call fresh offer, which is now left for Mr. A to accept. There was a particular case of high advisor's range. So where an estate was offered for sale at £1,000. So the offeree counter offered to pay £950, and when that was rejected, he purported to accept the defendant's original offer. So the offeror rejected the acceptance. The offeree sued for breach of contract. It was said that the counter offer was a rejection of the original offer. So because of that, the offeree could therefore not go back to accept same unless the offeror makes another offer. So that is what we call counter offer. And also we have number 3, lapse of time. Lapse of time means that if the offeror promised to leave the offer open for a particular time, then it lapses, the offer become terminated or terminates after the period. If the offer is left open or is to be open for 1 week, then after that 1 week, offer lapses. And now we have 4, debt before acceptance. So debt of the offeree or offeror terminate the contract, okay, terminate offer. So debt before acceptance terminate an offer. Then we have number 4, occurrence of condition, either occurrence or non-occurrence of condition. So if I should announce that I will sell my biro to, if Mr. A should announce that he is to sell his biro to Mr. B, as far as Jelili remains the governor, Jelili remains the governor of Lagos State. So it means that the offer will remain open as far as Jelili is still the governor of Lagos State. So that means that after Jelili is no more in office, the offer lapses. That's what we call occurrence or non-occurrence of condition. If Mr. A should tell Mr. B that he will leave the offer open for the whole of the rainy season, it means that after the rainy season, the offer lapses. So that is what we call occurrence or non-occurrence of condition, terminate an offer. So we have these 5 that terminates an offer: revocation, rejection, lapse of time, debt before acceptance, and occurrence or non-occurrence of condition. Then let us look at acceptance. We have talked about offer, so we have finished offer. What we want to go into now is acceptance. As I've said, we have legal requirement for the formation of a valid contract. We have done offer, so the next one, number 2, is acceptance. So acceptance of an offer is from the offeree. So offeree, where the offeror give an offer, acceptance is from the offeree to accept the offer. So where there is an offer and where there is an acceptance, contract becomes established. Okay, that's the first stage. Acceptance is signified the offeree intention to accept the offer. So let's have it this way, that acceptance is the final expression of assent to the term of an offer. It is the final expression of assent to the term of an offer. So that means that it is the statement, the move of the offeree to accept the proposal of the offeror. So that is acceptance. So it's the final expression of assent to the term of an offer. And where there is an offer and there is an acceptance from the offeree, then the contract is established. So, and also you need to know that silence does not constitute acceptance. So acceptance must be communicated to the offeror. So there must be a communication of acceptance. So that means that if the offeror wants to accept the term of the offer, he must inform the offeror. That is, if the offeree wants to accept the term of the offer, he must inform the offeror. So it must be communicated. Acceptance must be communicated to the offeror. So acceptance must be communicated to the offeror. By the offeree. But there is an exception to the rule of communication of acceptance. And let us look at those exceptions. The exception to the rule of communication is that where the acceptance is by post, then it is not compulsory that the offeror must be aware. Or let me put it this way, where it is by post, it is not compulsory that the letter of acceptance must get to the hands of the offeror. Yes, what matters most is that the offeree must post the letter, and there must be an evidence that the letter has been posted, enough stamp has been bought to send the letter, and the letter is directed to the rightful address. So if that is done, then whether the offeror get the letter of acceptance or not is not the concern of the offeree. The contract becomes established. That is the exception to the rule. What I'm trying to say is that the general rule is that the letter of acceptance, communication of acceptance must be known to the offeror. The offeror must get the letter. He must be aware that the offeree is accepting his proposal. Okay? But then the exception is that if the letter of acceptance is posted to the offeror, okay, in that wise, if anything should happen to the letter, it will not be the fault of the offeree. The court will have it that the letter has been properly posted and the contract is binding. So under postal rule, it is not compulsory that the offeror must get the letter of acceptance, because anything may happen to the letter. It may get lost on transit. So if anything happens to the letter, the contract will still be held, will be binding on the parties. We have a case of Adams versus Linsell, okay? And on September 2, 1817, the defendant wrote to the plaintiff, offering to sell some wood and requiring an answer by post. It was held that the letter became binding when posted and not when delivered. Okay? The acceptance is also binding where the letter is not delivered at all. Okay? And provided the offeree has proof of postage as indicated. So, there must be a proof of postage and that the letter is directed to the rightful place. So that is what we mean by post. It is true. It's not communication of acceptance is not only when the offerer gets the letter, but when the letter is posted by the offeree. That is what constitutes communication in postal rule. Then number 2 exception is that where it has to do with unilateral contract, as we have in Cali versus Catholic small ball. Or promise to do war, unilateral contract, where someone is the one that is promising. Take, for example, where police is saying that they are looking for a criminal, they want somebody to give them information. So it is announced to the public. Anyone getting that information will only come to police to give such information. So that person does not need to come to police authority to enter into agreement with police authority. No. So where police authority is saying that they are looking for a criminal and they want somebody that can give them information and they give the person certain amount of money. So anybody that comes forward is not only coming forward just to accept. There is no need of communication of acceptance, but in that wise, performance, the person coming to give that information is what constitutes acceptance. So it is performance that constitutes acceptance in unilateral contract. And also, as we had it before in Cali versus a Kabuli smoke ball. So they made an advertisement that whoever suffer influence after using their smoke ball will be given some amount of money. So now it was an announcement to the whole world. So nobody will come to them and say, okay, let me first enter into an agreement with you. I've accepted what you have said. They don't want that. So they are announcing to the whole world, and performance is what constitutes acceptance. So these are the exceptions to the rule. And also have this exception that where the offerer waive communication, that means that where the offerer tells the offeree that it does not need communication. So that also will constitute exception to the rule of acceptance. That exception to the rule of acceptance, that acceptance must be communicated to the offerer.